Robyn Shepherd and I'm an attorney. I practice as such at SchoemanLaw Inc. based in Cape Town, South Africa, where we proudly serve the legal needs of the entrepreneur. Today I will be talking about the formalities of a partnership in South Africa. Individuals as well as any other legal entity, namely companies or closed corporations, can enter into a partnership. This means that two or more individuals can enter into a partnership, or an individual or individuals can enter into a partnership with a company, or two companies can enter into a partnership with each other. Normally, where two companies enter into a partnership, it is to work together to perform a specific job, and at completion, the partnership is ended. This is usually called a joint venture. A partnership is entered into by simply signing an agreement that is specifically drafted for the partnership. Such agreement has certain requirements before it can be called a partnership agreement and before one can say that a partnership has been established. It can also be a verbal agreement as well. A partnership is also not a legal entity. There are 5 requirements for a partnership, and they are the following. There must be an agreement between the parties to form a partnership. The agreement must state that the relevant parties are entering into a partnership with each other by signing of the agreement. It is not a requirement that the agreement is in writing, but it is always better to have an agreement which is a written one. The parties must also have a common goal to make profit, and each partner must make a contribution to the partnership, and such contribution must be unconditional. This means that each partner must contribute either cash, labor, expertise, skill, or any other form of intangible asset. The partnership agreement will state how much each partner will contribute. For example, Mr. A will contribute 100,000 Rand in cash, and Mr. B will contribute 30 hours of work per week as a cashier. The amount and nature of each partner's contribution does not have to be the same. One can contribute less and one can contribute more, in accordance with the next requirement, which is there must be a profit sharing ratio. This means that each partner must be clear on what they will get. For example, Mr. A will be entitled to 51% of the profits, and Mr. B will be entitled to 49% of the profits. The partnership must also be carried on for the joint benefit of the partner. That wraps up all the requirements. Thank you for joining me. Please like, comment, share in the box below, and please don't forget to subscribe to our YouTube channel and our newsletter. For more information, go to www.SchoemanLaw.co.za.